matter after 2 weeks.
Highly obliged, Lordship.
Supplementary list, item number 1.
In fact, this matter was listed yesterday, my lord,
Yes.
since I was in the other court. So, my
That is
lord,
why-
here the DSU had personally come and met me on Friday, my lord, last Friday. So, my lord, there, according to them, she has already participated, but as far as the record is concerned, my lord, they sought for a little more time because this is pertaining to exam which has happened much earlier. So that is the only difficulty. My lord. Otherwise, it was an affirmative. I had to explain the situation. So, but they said that she did appear, my lord. So the record, since it's pertaining to old record, so I'm requesting for a little more time.
Because that would be the pertinent point.
Yes, my lord.
to be-
This is the second stand they're taking.
No, this is
The first stand was that my service was not continuous.
no, my lord.
They could not produce the records.
Everything
But
is
this
there
is
on
the
the.
second stand. They're
This
saying
is
that
not the second
I've
stand.
participated in
My
the exam.
my friend should go
But
through
that
the.
advertisement was
you
not
need not
annexed.
worry.
My friend should go through the
We'll go into
record.
the affidavit.
Yes,
If that is one of the
all the
pleadings,
averments are there, my lord. In
But
the
they have not annexed that those advertisement also.
anyway,
Lord, we
let
have
him
the
produce the record.
permission. We have enclosed the permission, granting her the permission to appear. That is there, my lord.
You do so. I see. This is a long pending case. We can't.
Exactly, Lordship.
My lord, petitioner doesn't have a case. Nevertheless, my lord, I'll pray for some time.
Mr. K.P. Bhattacharjee, Leonard G. has once again sought for time to produce the relevant records which were called for by this court. What is the order?
My lord, that to regarding the advertisement, my lord.
No, what was the order whereby the records were called for?
My lord,
To produce that
in the
advertisement,
course of the
Lordship,
hearing, my
because
lord.
they've said that those are
I'm talking about the order.
Yes, my lord. My lord, the order is dated 14/2/25.
14/2. Right, order dated 14/2/2025. It's because you have maintained that you were not called, you had no knowledge of the selection process.
I was asked to sit for NET exam.
That is incorrect, my lord.
So now they say otherwise. We'll check the records.
Our affidavit is filed long back, my lord. This is the stand. All the stand is there in the affidavit itself.
MTET exam is one of the qualification criteria, Lordship, requirement.
That is as
So I
far
was
as
asked to sit for that exam.
that is as far as qualification is concerned.
So I sat for that exam. No dispute
Nowadays,
about it,
unless you
Lordship.
pass MTET, you cannot. Yeah,
Exactly,
I mean,
Lordship.
you
So I was
cannot
asked to
teach.
sit for that exam only,
My
Lordship,
lord,
not for the selection process, Lordship.
that is not true, my lord. The truth will be out.
On the same to be objected to by petitioner. The same not be objected to by petitioner. Pray aloud.
Let it be last chance, Lordship.
However, it is
Not a question of last time, my lord. This is a record, my lord. They'll have to trace and bring it on record, my lord.
This will go on, Lordship. They'll keep on seeking time, Lordship.
once the court has passed the order, it is incumbent upon you to do it.
Lordship, since
Either if you
In
have to,
fact, that is why.
if you have to work 24 hours, you have to do that.
No, that
June
is
last
exactly
year,
why
Lordship,
they
kindly-
personally.
kindly see, Lordship.
No,
Let
the
us-
petitioner
see, let
doesn't
us-
have a
let-
case. I don't know why the
let the
petitioner is
records be
harping on
called
this.
for.
Lordship.
The court will have a clear picture of what the issues is. This is matter of the 2 weeks.
Obliged, my lord.
No problem.
Daily list, item number 1.
Please, Your Lordship, I pray for 2 weeks' time to file my rejoinder.
All the respondents have filed their counter.
For the Contempt.
Mr. Leonard Counsel for the petitioner has sought for some more time to file the rejoinder to the counter affidavit filed by the respondent. On premier, the same is allowed. This is matter of the
Lordship.
Item number 2.
Yes.
Your Lordship, actually, I could not contact with the that is respondent number 1. Although I have received the copy from my friend, because his previous phone number is not working. So kindly they may be directed to take step, formal step. Your Lordship.
You have
Just for respondent number 1.
yes, you have entered appearance,
Yes.
and you are just to file a power.
Yeah, supposed to. But thing is that I could not contact with the client. He's from Assam. Your Lordship.
Then why would you now you're pushing the burden to them?
No, thing is that actually I received the copy as a previous counsel. I was the tribunal. I was
Now
there.
you have done that. You have taken that responsibility. It's for you to either convince the client or get a specific instruction that they are not, engaging you anymore.
I could not contact my lord, so I may be given one more time.
Fine.
Your Lordship, with respect to respondent number 2, my Lord, we are supposed to file an affidavit of service. We are just waiting for a signature, my Lord, if we can file it within the course of the day.
On premier by the parties, let's just matter up to 2 weeks. Please do that.
All right.
Item number 3.
Lordship, here the bail application which I moved for the accused persons, this is under the NDPS Act. On 5th September 2024, because we asked for, we were thinking that the trial would be concluded by this time, September 24 until today. I filed a synopsis, Lordship, if you have a look on the synopsis which I filed. The synopsis I have indicated that the instant bail application was filed for on behalf of the accused person, namely so-and-so, on 5th September. These are the list of the witness. These are the witness to be examined. Now, the accused person was arrested on 19 June 2023 and charge sheet filed on 20th July 2023. Thereafter, after supplying the copies of the charge sheet and other related documents, the Special Court Cleared framed the charges against the accused person on 13th February 2024. Since there was a delay in conclusion of the trial, the accused person found the trial of the case would not be concluded within a reasonable period of time. Hence, filed a bail application before the Tribunal Court. It was moved on 9th September 2024. At the time of filing the bail application, only 2 prosecution witnesses were examined on 5th July 2024, PW1 and 31st July 2024. 2. The prosecution and defense we made a prayer that maybe pending these bail applications, witnesses would be examined. So many dates the case was adjourned, which I have indicated here: 9/9/2024, 24/9/2024, 3/10/2024, 17/10/2024, 4/11/2024, 19/11/2024, 5/12/2024. These are the date case adjourned.
See, these on the dates that the case was adjourned.
Case was adjourned. But there is no witness present.
No
No witness present. But after the bail applications filed, there are 2 more witnesses examined, which I have already indicated here. During the pendency of the bail application, only 2 witnesses were examined by the prosecution on 2/12/2024 SPW3 and 7/3/2025 SPW4, while the accused person are being remanded for the custody after every 14 days. However, apparently there was an inordinate delay. So my case is on the delay because the accused person there in the jail for almost going to be 2 years, and the trial is yet to be concluded. Apart from that, I enclosed the copy of the depositions of the witnesses. None of the witnesses has said anything against my accused, which I am moving the bail, because the recovery was not made from my positions. It was just somebody, the co-accused, given made a statement that this thing belonged to so-and-so. That is the only evidence as on today found on the records. Otherwise, no, nothing is there. So, on account of delay, Lordship, this is a fit case. If I rely one of the judgment, if the Lordship I could not get the correct copy, but because of the delay, para number 8, 9, 10. These are the relevant paragraph. That it is informed by the learned counsel for the parties that the appellant has, on the date of more than 1 year, 11 months in the custody, the investigation is complete. Framing of charge is yet to be done. The conclusion of trial will thus take there are no criminal antecedent. It is seriously debatable question of fact whether the appellant was also found in conscious possession of the contraband. But such question of the fact will obviously be determined by the trial court at an appropriate stage. That being so, it seems to that of now, twin test of 37 of the Act need not to be invoked against the appellant, taking into consideration the totality of the circumstances, especially the period of custody undergone by the appellant. However, without expressing any view on the merits of the case, the appeal is allowed. Accordingly, the appellant is ordered to be released on bail, subject to the furnishing the bail bonds of the. So my case is clearly covered by this judgment. Here also, trial is yet to be concluded, charge frame, and I am then the custody for a long period of time. So incarceration is there, delay is there in the trial, and we are facing. So I humbly pray, Lordship, this is a fit case. If the bail accused may be allowed to go on bail.
Yes, Mr.
May it please your Lordship. Lordship, an earlier bail application has been filed. Lordship, kindly come to page 53, your Lordship.
Yes.
Lordship, kindly come to para 30. This court also has been has to keep in mind that the accompanying factor which led to the judgment of the against, which was based on the seizure of the said ganja, are the same being in commercial quantity. The provision of section 37 would apply. Lordship, it is the admitted fact, Lordship, that the case involved here is of commercial quantity. The charge sheet having been filed, the petitioner have not been able to argue the case on its merit, and therefore, as has been noted above, the record of provision of 37 would apply to the case of the accused person in question. So, Your Lordship, 37 will come into play, Your Lordship. Today, Your Lordship, the sole contention of the bail applicant is that there is a delay of trial, Your Lordship. Lordship, kindly see, Your Lordship, there are only 9 witnesses. 4 witnesses had already been examined and cross-examined, Your Lordship. Remaining is only 5, Your Lordship. It will not take time, Your Lordship. And he was arrested, Your Lordship. He was arrested only in 96-23, Your Lordship. Not even 2 years, Your Lordship. Not even 2 years. Hopefully, Your Lordship, the trial will conclude very soon, Your Lordship. Kindly see, Your Lordship, the case involved of commercial quantity, Your Lordship, and there is a clear finding of this honorable court in the earlier bail application, Your Lordship. The case, the bail was not argued on merits, Your Lordship. It's only on the delay of trial, Your Lordship. Where is the question of delay, Your Lordship? What is a reasonable? Not even 2 years, Your Lordship. It is not unreasonable delay, Your Lordship. It's not unreasonable delay. If it is 5 years, 6 years, yes, certainly, Your Lordship, I would concede yes that would amount to deprivation of a speedy trial. But they hardly, not even 2 years, Your Lordship. 251 kgs, Your Lordship, have been seized. And these are meant for distribution in the state, in Shillong, Your Lordship.
See, Mr. Qureshi, since you're pressing only on delay, now the observation of this court would be this, that had there been, a delay as far as the proceedings are concerned, if suppose now one witness has been examined today and the next witness is examined a year after, and maybe,
Yes,
but the fact remains that you yourself have pointed out that as recent as 7th March, the fifth witness was, the fourth witness was examined. So,
and the next
so it can be presumed that there is no stagnation as far as the progress of the case is concerned, and we should allow the trial court to. It would be in your interest if you see the proceeding is concluded as soon as possible, and if you are indeed innocent, then you'll be
Lordship, in this case, I have already pointed out The contravention was not recovered from me. This is the judgment applicable here. One of the point of factor considered by this court also. There's no conscious positions, they said, and the period which is counted is 1 year 11 months. Lordship, in this case, what happens? What the trial judge is doing, one date fixing for productions, 14 days, and after 14 days, then evidence. Means it takes 1 month for the witness to be examined. But as per section 309,
See, this court may request the trial court to proceed expeditiously as far as recording of evidence is concerned, to the extent possible. If you, as you said, if the case can be taken up fortnightly, as and when the accused are produced,
Lordship.
then
Lordship, the evidence so far adduced by the prosecutions, 4 witnesses examined.
exactly
I have not found anything against me in these cases.
that will be for the trial court to decide.
But the trial court is the way trial court is proceeding. Prosecutor may agree. 40 as per 309 CRPC. Once the trial starts, it should be day to day.
That's what I'm saying. That's what
But,
I'm saying. At best, this court can request the trial court to expedite the.
Next date is on 21st, Your Lordship.
So, Lordship,
For evidence.
Lordship,
For evidence.
Lordship, let the matter be pending. I'll just wait till 21st, as he's saying.
Lordship
It's
is
just
next date of hearing, next hearing date 21/3 to 25, Your Lordship.
Why would you want to keep this pending?
that's what because. In fact, we want that the court should supervise that there's a spirit trial. Because if there's no spirit trial, it also violates the rights of the accused person. Article 21, it violates.
You are, like I said, you do not get my point. I'm saying that this court will request the trial court. It cannot direct.
Lordship, yes.
That is, see, the Supreme Court is very
Recent
clear.
judgment, Your Lordship, on
Supreme
that.
Court is very clear on
Lordship,
that.
one date for
we cannot
production,
give
one date for
timelines.
evidence, that is also unfair.
That is for you to argue before the trial court.
But in the court has to set the guidelines for the trial court how to proceed. Because as per
let any order be passed in that regard, and then if it is adverse to you, you can always come before this court.
yes, because 309 CRPC says what it says, Lordship. If I just
And that is well settled. We know how
once
the trial
hearing
is to proceed.
starts, it should be day to day.
Mr. Qureshi, let me ask you. I've also been in your shoes.
Yes, Lordship, that
Is that practically possible? Is it practically possible? Is it followed to the letter? That every case is taken up on a daily basis?
Lordship, if I agree, Lordship, that. But one date
More
for
often than not,
Lordship also was before the trial court had done many cases. We never complained because court was very prompt in taking the matters. But one date for productions.
I have not recalled any matter where I have taken up,
Yes.
recording of evidence at least 5 days in a week.
Yes. But here, Lordship, one date for production, one date for evidence. it goes 28 days.
You can advise the PP to at least proceed with the matter.
And all the witnesses are from July only. It's very easy to examine at least 3 witnesses in a day.
We'll see. After 2-3 weeks, 2-3 months, maybe you can come back. We'll see. You want to keep it pending, or should I dispose it?
Let it be pending, Lordship. I'll just see the.
Or pre-made by the petitioner. List this matter after 4 weeks.
Apply, Your Lordship.
Item number 4.
Lordship, our efforts to get complete address from the driver also failed because I am informed by his.
No, but you have been given yes, you've been allowed to issue notice by substituted method.
Substitute service by publication in the paper.
That has been allowed in the last order. Have you done it?
But I was not. I was asked for
Lordship, I have asked my client whether he knows and all, because after the accident, after 6 months, he left the vehicle driving. So I asked him. He said he does not know. He's from village boy. He does not know where is the address and the phone number also.
I was not aware of this order, last order.
Mr. Lordship, your junior at least should have read the order. What does it say? You see, Therefore, fresh notice by substituted method should be method on respondent is allowed to be affected.
I'll do it.
You could have done that.
Let the matter come after 2 weeks.
Mr. Vicky Jindal, Senior Counsel, has submitted that some more time is required for the
Mechanical
to take steps for issuance of notice on the respondent number 1 by substituted method, that is by publication in a daily newspaper wherein the last known residential address of the said respondent 1 is on record. Since you will not know where's the address,
Yes.
so the last known address,
Yes.
take steps on. Even it's Guwahati or Shillong or
I'll do it.
as prayed for, this is matter after 2 weeks.
Obviously.
Item number 5.
Mr. Burwa, I think you have to start from
Yeah.
beginning. You have to refresh this code.
Okay, I'll just.
But do we have time today?
Okay, but my friend is. Lordship, may have it after 2 weeks.
We'll have Monday. Why?
Monday.
Why 2 weeks?
Monday.
Monday.
Okay with you Monday?
Just,
Mr.
It's
Barwa
an
has
old
got
case which
BG calendar. Yes, old BG calendar.
that liberty is always given to head counsel
yes, complete. Lordship.
Monday. Monday.
on premier with the parties. This is matter on Monday.
A pleasure.
Item number 6.
6 and 7 are connected, my lord. It's a lengthy matter, my lord. If your lordships can have it on Tuesday, we'll finish it off on Tuesday, my lord.
Yeah, no. Tuesday. 18.
Tuesday won't case now.
18th.
18. Let's come on 27, your lordship.
27.
27.
Huh? 27. 18 you have problem
27.
My lord, no problem.
on concern by the parties. This is matter for hearing on 27.
27. Oblige,
Fixed
your
date.
My lord. Item 8, my lord.
So that is 6 and 7.
6 and 7.
6 and 7, your lordship. Yes.
Item 8 is also my matter, subject to the convenience of your lordships. Anytime Tuesday, Wednesday.
This is also where the number of private respondents. isn't
The
it?
private
Yes, my lord, but
respondent.
now it won't affect them anymore because since I have since retired, so there won't be any effect. It will only be notional
My lord,
promotion.
even the
what would
private
be the-
respondents, my lord, if
What
my
would be the effect of notional promotion?
Just the financial
benefits. And even the private respondent, my lord, I believe almost all of them has retired.
Who's appearing for private
My lord,
respondent?
Mr. Karmo Plang was representing Ms. E.B. Pasa. My lord, I believe they were not aware, court has already said. I believe they, 2 o'clock, my lord, I believe they have thought about it.
So we'll go to the tea shop where they are on premier parties. This is matter after 2 weeks.
deeply.